All right, everyone. Thank you so much for coming to our virtual talk tonight. My name is Zate Mueller. My pronouns are he, him, and I am a board member of PFLAG San Francisco, which works to create a caring, just, and affirming world for LGBTQ plus people and those who love them. We offer a monthly support group every second Tuesday and fourth Thursday of the month. This Sunday, we are participating in the AIDS Walk. If you're want to join us, you can find a full list of our events at pflagsf.org. A special thanks to Ann Daniels for connecting us with Ora today, and to Seth Froman for setting all of this up. Today, we are pleased to welcome Ora Prochovnick, Director of Litigation and Policy at the Eviction Defense Collaborative. It's the lead agency for San Francisco's Tenant Right to Counsel program. Ora brings over 35 years of experience in the Bay Area's legal services community with a deep focus on tenant advocacy, civil rights, and queer family law. A founding partner of Bayside Legal Advocates and longtime legal educator, Ora has shaped generations of public interest lawyers. She's been honored multiple times for her commitment to justice and service of low-income communities, and is a passionate advocate, educator, and proud parent of 2 adult children alongside her partner of 42 years. She said you have a presentation and we'll hold the questions till the end, but please welcome Ora Prochovnick.
Thank you very much for that introduction, and thank you for inviting me to speak with you all, and thank you for your concern and passion and love for your families that you want to spend a Tuesday evening talking about tedious law stuff. So I'm happy to uh, have this opportunity to share some information with you. As you could hear from the introduction, these days I'm hanging out at the Eviction Defense Collaborative doing tenant advocacy work and trying to keep people in their homes. But I did work for many, many years helping with uh, LGBTQ families do family creation protection work, and also taught courses on it. So I sort of pulled on some of that history in order to ground myself to speak with you all today. And I am going to share my screen, and hopefully you all can see that. And when I'm sharing my screen, I can't see you all so well. So if there's something you're not hearing, feel free to unmute or shout out if I need to do something differently. So we're going to be talking about the legal rights and risks for trans youth and their families. And how we were chatting before the Zoom started with that when Anne reached out to me a couple of months ago to ask me to do this, I said, sure. I had some very cheerful, happy, good news I thought I was going to share with you. And then our friends on the Supreme Court did their thing, and it's really had caused some change in what it is that I'm going to have to be talking about today. So just a quick overview of what I'm going to cover, which is stating the obvious, I guess, that the legal environment for trans youth is rapidly evolving. Like every day, if you have the stomach to read the paper, you're going to hear something new. I want to emphasize that there are significant disparities between state and federal policies. I'm going to be talking to both because besides living in California, we also live in the United States. And so the rules of both government levels affect us. But just be aware that there's huge distinctions between them. And I'm going to be talking about those distinctions and how they affect us in our day-to-day. And what I'm going to be aiming to do is just provide some up-to-date overview of these legal realities as they're changing in front of us. So we're going to start by looking at the federal landscape. The situation at the federal level rapidly began changing the moment our current president came into office. He signed a number of executive orders in January of 2025. I've highlighted the most significant ones that have a bearing on the legal rights of trans youth. So Executive Order 14183 bans transgender individuals from military service. So for our kids who are under 18, that might not mean anything. And those of us who don't think a military path is what our kids want to do, it's still huge in that the military has always been a way for particularly low-income folks to get access to education, to jobs, to getting out of their small towns. The rationale for this is the executive order cites concerns over unit cohesion and readiness. We're going to be talking about some of the court cases and challenges. This executive order has been challenged to the courts, but it is currently today in effect. We've also seen over the years, like from the history of banning all queers from the military and then don't ask, don't tell, and then admissions, that uh, how society as a whole treats folks in part is a reflection on their access and right to things like military service. Executive Order 14168 is really a winner. It withdraws all federal recognition for transgender people. So really, this one just affects everything. It affects passports, prisons, and where you can be housed if incarcerated, gender-affirming care funding, which is something we'll be talking about more. And also, it's causing trans folks to disappear from history, just overnight, getting wiped out of various. If you go to Stonewall in New York, a national monument, even though the rioting there was generated by these amazing drag queens and transgender folks, they've disappeared from the acknowledgement of what's going on. So just a complete wipeout. And then Executive Order 14187, which created health care restrictions, federal funding withdrawn from any institutions that are providing gender-affirming care to minors, and also important healthcare programs that are federally funded, like Medicaid and TRICARE, have eliminated protections for anybody who's trans. So if that's not cheery enough, we're going to now look at the judicial decisions that we've had that affect the federal landscape. And in particular, our most compelling recent decision, the United States versus Scrimetti. This was a lawsuit where the Supreme Court reviewed whether a state law passed by the state of Tennessee, which banned gender-affirming care for minors, whether that law violated the Equal Protection Clause of the 14th Amendment to our Constitution. And in a 6-3 vote, our U.S. Supreme Court upheld that ban. So it allows Tennessee's ban on puberty blockers and hormones for minors to go forward. The court, I guess if we want to find a couple of silver linings, one of the things is that the court, the Roberts decision, really focused its ruling on saying that the ban was based on age and treatment, and therefore it wasn't sex discrimination. It was quite a contortion that the court went through to come to this conclusion, but it could have been worse in that they could have decided that it is discrimination and we don't care. And that's really where Sam Alito went in his dissent. So if you really want to focus on something horrendous, take a look at the Alito dissent and the Scrimetti decision. There's a piece of me that has to really sort of appreciate the honesty of that dissent, because it's really where all 6 of the folks on the majority side were voting, but he said it out loud. What he basically says is, hey, I'm dissenting because you're pussyfooting around, and really what we should be saying here is it's just fine to discriminate against trans folks. Whereas what Roberts very carefully does in the majority decision is to sort of say, hey, both male-assigned and female-assigned patients are blocked under the law, so can't possibly be sex discrimination, which is the same really brilliant reasoning that they used to use to say that prohibitions on same-sex marriage wasn't discrimination based on sex, because we equally discriminate against everybody because of their sex. It's kind of ridiculous, and Alito was right to see the ridiculous on that, but the conclusion should not be that it's okay to discriminate. Some other things to say about this court decision. Again, it's narrowly focused, and it doesn't automatically extend outside of Tennessee. So it's important to know that nothing in this decision says that a state is required to ban healthcare for transgender youth. It says that they're allowed to do that ban, and it's up to the states to decide if they want to or not. So why it's horrible? This decision matters nationwide, even for those of us living in nice, safe, healthy California. In addition to Tennessee, there are 25 other states that currently have bans that prohibit or limit this type of health care for their youth. And it allows those 26 state bans to remain in place. So that's going to affect over 100,000 trans youth and prevent them from getting the care they need. We all know that this means it disrupts trans youth's mental health care, and it increases risks of depression and risks of suicide. And what it does is it validates the state's authority to regulate medical care for minors, just in particular within this context. Although I think what Roberts was trying to say in his decision, it's because it's medical care and because it's minors that the state does have a right to intercede. Really shocking is that about 40% of transgender youth who are between the ages right now of 13 and 17 live in states with some type of law in place that will limit their access to gender-affirming care. So that sort of is the heartbreaking part of this decision. We know that trans adolescents need all the same things that every other kid needs. They need loving families. They need safe schools. They need essential health care that will let them grow into being the happy, thriving adults that they're trying to become. And what this Supreme Court decision did is it allows laws like Tennessee's to stay in place that are nothing but cruel and discriminatory. So we have some fighting ahead of us, but that's the conditions that we're living with right now. But Scrimeti is not all. No, we had other things to keep us entertained that the Supreme Court dished out this term. They've been very busy this term. So I just want to give a brief highlight also to a few other cases. Schilling versus United States is the case that dealt with the executive order that I mentioned earlier, that Trump's early executive order calling for all trans military service members to be discharged. That executive order was challenged in the Schilling's case. And in that case, the district court that heard it ordered the government to halt the implementation of the ban. It said that it was cruel and demeaning to trans members who had sacrificed their lives, who had served their country with honor, and that there was no basis for these discharges other than discrimination. So the court made a ruling that executive order could not be enforced and ordered implementation of the ban. And that was appealed by the government. And the Court of Appeals denied the U.S. government's request to let the military resume the ban while the appeal is pending. Went up to the U.S. Supreme Court, and on May 6th, our U.S. Supreme Court stayed the district court's order allowing the ban to go into effect. So again, it's horrible. That ban is now in effect, but it was not a final ruling on the case. All that the Supreme Court did was allow it to remain in effect now while the case moves through the court. So it's not a final decision in the case, but it does open the door to this cruel and unprecedented purge of very trained, capable personnel who are about to lose their careers, that they have worked very hard to establish and that they have served their country, in some cases for decades. There's also some worse news about this because the military plans to implement the ban using what's called administrative separation. That's usually reserved for misconduct in the military, so it creates a troubling record for the people who are discharged. So the various legal agencies, NCLR and GLAD on the East Coast, are going to continue their lawsuit against them. The Mahmoud versus Taylor case was a decision which was issued in late June, on June 27th. Irony not lost that was almost to the day on the anniversary of the marriage decisions case. And this case dealt with a decision out of Maryland that dealt with school district curriculum policy. The county in Maryland where this case came from, Montgomery County, had a school curriculum that called for LGBTQ inclusive text to be used in the classroom. And just like the parents couldn't opt out of history classes or math classes, they also couldn't opt out of the lessons where that material was being included. In Mahmoud, the U.S. Supreme Court ruled that that the school district had to allow parents to give the right to opt their children out of reading those books, and that refusing to let them opt out was a violation of their free exercise of religion. Once again, it's important to know that this is not like all bad, in that the decision does not prevent school districts from adopting LGBTQ inclusive curricula. It is important that we still work with our schools wherever our kids are going to make sure that the curricula is appropriate, that certainly the San Francisco Bay Area schools are continuing to have really important LGBTQ inclusive course materials. All students benefit from learning about the full diversity of our society, and it is a shame that some of the people who most need to be in that room aren't going to be there because of this decision. But again, that doesn't mean that we shouldn't continue to have strong materials in our schools. Same day as Mahmoud came down, the Trump also issued its decision. The court issued its decision in Trump versus Casa. That dealt with Trump's birthright citizenship executive order. And once again, the court did not address the merits of the case, but what it instead addressed was whether a lower court could issue a ruling that enjoined an order nationwide. So in the Casa case, the lower court said that the ban against birthright citizenship was a violation of the constitutional rights of the plaintiffs, and also prohibited any other people similarly affected from having the ban applied to them. The court ruled that lower courts could not issue such a broad ruling, that they could only very narrowly say the government can't enforce its executive order against the plaintiffs in this case, but they couldn't broadly stop the government from enforcing it altogether. So although that's not an LGBTQ case, it doesn't affect our trans kids. I kept it on this list because it takes away a very important flexible tool that our legal agencies and organizations have long been relying on, which is to challenge unconstitutional government action and have it apply across the board while the case is pending, instead of just to the one or two parties who are actually bringing the case. The court decision did have a little loophole, and it said that these challenges can still be brought as class actions and get broader relief. And a very recent lower court decision took that and ran with it and turned the case into a class action. So we'll continue to see how this thing plays out. And finally, I just want to highlight a couple of cases that the court has not yet ruled on, but what the court did is it announced that it's going to hear these cases next term. So next June, we will be either grieving or celebrating the court decisions in the Little versus Hickox case, which is out of Idaho, and the West Virginia versus BPJ case, which, as you might guess from its catchy name, is out of West Virginia. Both of these cases, so they're going to be combined and heard together. They both concern state policies which ban transgender girls from competing on girls' teams in school sports. And so again, there are cases very near and dear to our hearts that will greatly impact our families, and we're going to follow them closely. Uh, there are some other cases that are already pending in Arizona and Utah that a number of civil rights agencies have been involved in challenging them as being unconstitutional. So there's across the country effects that are going to come out of these two cases that the court has just agreed to hear. What I've been sharing is what's been happening at the federal level through court cases and executive orders. What I want to briefly also look at is that even though we have a federal system of government, which means that the states can do their own thing and the feds do their thing, and we have different areas that we're supposed to address, there is local impact from the pressure and the scrutiny that is coming from the federal government. So we have in particular seen some closures of healthcare clinics, which is causing a disruption of gender-affirming care for trans youth that require it. So most appalling was when Children's Hospital LA, CHLA, it has announced that it's going to close its Center for Trans Youth Health effective on July 22nd. So next week, a week from today, that center is closing. And there is absolutely no doubt that they are doing this because of federal funding pressure. Basically, they're chopping off an arm so the whole body won't die. They are getting a lot of threats about loss of funding if they kept running that program. Stanford Medicine has decided as of last month, early June, that it's not closing, but, quote, pausing any gender-related surgical procedures for youth. And once again, it was because of threats of funding loss and legal action from the current federal administration. So even though full care for trans youth is completely legal, we talked about a Tennessee ban that's now been upheld and is mirrored in half the states across the country. But California has very strong protective laws that we're about to look at, but we're still impacted by agencies and medical facilities that cave in to the threats that are coming from the Trump administration. But the flip of that is that the state of California is threatening back. So our attorney general, who, whether you love him or not, he's been doing some incredibly strong litigation to support LGBTQ issues. He has been threatening to sue both CHLA and Stanford for violating the Under Civil Rights Act. And we're going to be talking about that Civil Rights Act a little more later tonight. But he's saying if they're withholding care, just because they're scared, does not justify violating people's civil rights. All right, so we're going to move now to California from the federal level. And I want to start off in particular highlighting SB 107, which went into effect in January of 2023. And people refer to this as our SHIELD law. It was passed and signed into law in 2022 and became effective at the beginning of 23. And it protects access to gender-affirming medical care for minors. It safeguards minors' access to care and blocks any out-of-state restrictions. So it prevents enforcement of any out-of-state laws regarding that care. So even though we just saw that our Supreme Court has upheld any limitations on this care, California is saying those limitations cannot hurt our kids. So it's basically creating a trans sanctuary in the state of California. It's creating a safe harbor for out-of-state youth to come here seeking care. And even if their home state prohibits them doing that and makes out-of-state care illegal, California says, no, it's legal here. And it prohibits enforcement of any out-of-state orders regarding that care. So out of a different state cannot prevent a child coming to California and receiving care. And it also prohibits disclosure. And there are also protections against custody loss, which is particularly important where you have families with in-state and out-of-state parents, and prohibits any harm to that right of custody for the in-state parent providing gender-affirming care. So it's a great law, and it's something we should all take a deep breath around and rely upon. I will just add to that on top of that, several cities, including the one I am sitting in right now as I speak to you, have formally been designated as trans sanctuaries. So San Francisco, Los Angeles, and Sacramento have all passed laws to layer upon the state protection. So they didn't need to do these laws because we already have a sanctuary protection through SB 107 across the state. So really they're symbolic, but that symbolism is really important to say that anybody who lives in our city, we see you, we want you to get whatever care you need, we'll protect you, and we'll protect you even if you come here from out of the city. All right, moving on from there, I'm going to go through a number of other California laws that are in place that provide some strong protections, and then I'll talk about some risks to some of those laws. So last year, AB 1955 went into effect, so exactly a year ago in July of 2024, and it was written to particularly create safety for students in school. So it prohibits schools from any forced outing of their students, including to their parents, disclosing things that the students themselves have not chosen to share with their parents, and supports student privacy. There is a lawsuit that I'll talk about more in a little bit that has been brought by Chino Valley and Huntington Beach, challenging the Safety Act. But right now it's in place and functional. There was no injunction issued as a result of that lawsuit. We also have a law that protects transgender student rights, so their access to school facilities and sports. AB 1266. It was originally passed back in 2013 and then has been amended since then to add more protections and strength. Under this statewide statute, there is an absolute right to participate in sex-segregated activities based on your current sexual identity, and a right to use the facilities connected with that, such as the locker room, based on the student's gender identity. Once again, with these strong protections we have, we invite threats. So there has been no lawsuit yet filed against California for its enforcement of AB 1266, but at the federal level, there's been a threat from the Department of Justice that California can be sued. They are claiming that our provision of this full participation in sports and facilities violates Title IX. So that's the theory that's being argued in those cases that the Supreme Court's going to hear next year that I already mentioned. And the Department of Justice has been threatening to file the suit. Preemptively, our Attorney General said, well, I'll beat you to it. I'll file a lawsuit first. So even before any federal DOJ lawsuit has been filed, California, through its Attorney General, filed to protect our state law and our state constitution for being able to continue to abide by AB 1266. So right now, this law is absolutely in play and providing its full protections. I also want to talk briefly about how California protects around public accommodations, which includes school facilities. So our primary public accommodations law is found in the Unruh Civil Rights Act, which states that access to any public accommodation, meaning not a private club, not my back bedroom in my home, but anywhere where the public is allowed to come in. So public accommodations include hotels, schools, the theater, the grocery store, anywhere where the public is allowed to come and is invited, cannot discriminate. What makes the Unruh Civil Rights Act a fascinating civil rights law as compared to any other has to do with how it's been interpreted by the California courts over the years. So it has the usual laundry list of protected statuses and categories. So it states that this prohibition on discrimination in public accommodations applies to people who have a status found on the list, such as race, ethnicity, national origin, gender, sex, gender expression or gender identity, age, family status, marital status, whether you have children, whether you don't have children. But in addition to having a very lengthy, extensive list, what the Unruh Civil Rights Act also has is an interpretation by our California Supreme Court that says that list is just meant to be examples. And in fact, Unruh should be interpreted to prohibit all forms of arbitrary discrimination in public accommodations. So the combination of a very extensive list that does include gender expression and gender identity and sex also expands beyond the items listed to any type of arbitrary discrimination. We also have SB 760, brand new-ish law affecting restrooms and locker rooms in school facilities, and it requires access aligned with the student's gender identity. And the law exists now. It's already been signed by our governor, but it doesn't become effective until January 1. So as of January 1, 2026, all schools have to provide single-stall, all-gender restrooms in their school. They are mandatory. And again, because our civil rights laws explicitly include the term gender identity, even without SB 76, it has been interpreted to ensure access to restrooms, to sports and activities, to all schools, to youth services, and to healthcare, which is why our Attorney General was threatening to sue for any potential denial of healthcare. And there are also privacy protections that attach to this. So if families are denied this, they can sue under Unruh Civil Rights Act. And I would argue they could also sue under Title IX, which has its ironies because Title IX is what the federal government is using to say that we can't give this access to sports. And I would argue that Title IX mandates that we give this access. So we'll see how our courts deal with that difference of opinion. Some other California legal protections that I want to make sure are on people's radars. These are not new things, so they're probably things that most of the people attending this workshop are familiar with and well aware of, but I think they bear repeating and reminding. So we have the Gender Recognition Act, which has been a law since 2017, which greatly simplifies the name and gender change on state documents. It both gives access to a much quicker, easier court process. You don't have to publish. You have your privacy. But it also allows the change on many documents without going through that court process. So you should be aware of those ways to both change name and gender markers on certain key California documents if that's something that people in your family want to do. We also have the California Mental Health Services Act, which creates a legal right to mental health care and expressly states that there's a right to gender-affirming therapy. So it's the opposite of the Tennessee ban. And the version of Medicaid that we have in California is, of course, Medi-Cal, and we have some rules regarding both Medi-Cal and health insurance, private health insurance coverage, that prohibits any insurance exclusions for gender-affirming care. Gender-affirming care is health care. Health insurance, therefore, should cover it, and it would be an illegal exclusion from either the state Medi-Cal plan or from a private health insurance plan. And therefore, it provides for some guarantees of access to hormone therapy and surgeries and so forth being covered by health insurance. Not that everybody has decent health insurance, but should you have access to that, it will cover that care. So I'm going to move on now to another category and talk about IDs and the closely related topic of travel. And again, there's differences between what we have here in California that I'll be highlighting as compared to what the federal government is saying. So we are now in the period of time where we have the real ID mandate. It finally went into effect in May of this year. They've been saying for the past 5 years it was going to go into effect, and it kept getting kicked down the road, and the kicking has stopped, and it's now in place. So if you are going on any domestic flights, you must either have a passport or a real ID compliant license or state ID. So if you are a driver, your driver's license needs to be real ID compliant. If you don't drive, you still need a state ID card, which is real ID compliant. And if you don't have that, you'll need a passport to be able to get on an airplane. And I just want to highlight something that I'll talk a little bit more, which is if there is a mismatch between the gender marker on that ID and presentation, it might cause greater scrutiny at the airport that pretty much all of us would rather avoid. That executive order I mentioned earlier, 14168, that shut down all things trans, also suspended having an X, or which is the neutral gender marker on the passport, or marker changes, changing from assigned at birth gender to current identity for any new passports. Brand new, hot off the press in the pending ACLU suit, that policy has been enjoined. So it's not currently being enforced. But I said, bear with me, the fact that things are changing every second. I can't tell you how long that injunction is going to hold. So let's look at the differences to how gender markers are handled between passports and the California IDs. On your California ID, whether that's a driver's license or a state ID, the person who's being identified is allowed to self-select how they want their gender indicated on their birth certificate and on their state ID. It could be male, it could be female, or it could be the non-binary X. And there is no longer a court proceeding necessary to do that, and there's no longer medical gatekeeping. So there was a time in fairly recent history where you had to have certain medical procedures or surgeries or doctor's notes. None of that is required now. The person whose ID it is can self-select what the appropriate marker is that they want. Changing that to the federal level for the passports, because of that executive order, the State Department announced that they will no longer issue passports with an X marker, and they won't allow changes in gender to be indicated on a passport. And if you have a current passport with an X marker or what they perceive to be wrong gender, they will not issue a new one when that one expires. So when it needs to be updated, it's not going to happen. However, all existing passports remain valid. So if your passport was issued and it doesn't expire for another 8 years and it has an X marker, it's valid for 8 more years with that X marker. Um, and as I said, the ACLU has filed a lawsuit and obtained a preliminary injunction saying this law cannot be enforced. So right now, this law exists, and at least as long as that preliminary injunction holds, doesn't exist. So that means that tomorrow you could get a passport with your X marker. So some people want to like run right up during this period of the preliminary injunction. This might be a great time. If you don't have an existing passport that reads the way you want it, now's the time when you could get it issued. We don't know how long this will last. There have been sort of anecdotal reports of seized documents when people are trying to come home over the border, or holdups and delays in traveling, or holdups in issuance of new paperwork, or insistence on reversion to sex assigned at birth. So I do want to acknowledge that there's a difference between what the law says is supposed to happen and what people experience in real life on the ground. So just looking at travel risks and dealing with those TSA folks. So we all have struggled with TSA telling us to take off our shoes, or take out our laptops, or go through this machine, or don't go through this machine, and getting pulled aside for added scrutiny and added questioning, and being told it's random, and many people thinking it's not random because everybody else goes through and the darkest colored person seems to always get pulled aside. But so once again, I just want to make people aware that in stories and shared anecdotes of actual airport experience, mismatched documents can result in invasive questioning from TSA and delays. And it really depends on what airport. And I would say that people who are traveling maybe want to do some questioning ahead of time of other people's experiences at particular airports. I have not heard of much of in the way of problems at San Francisco or Oakland, but maybe when we open this up for questions, people also can share experience that they've had that is contrary to what I've been hearing. That's unfortunately not the case at some other airports around the country. There has definitely been an increase in screening and an increase in misgendering of folks as they're trying to travel. The sort of already in place TSA procedures are supposed to flag so-called anomalies, and I put that in quotes, of things that are actually completely not anomalies and completely normal, are what they perceive as something that needs to be flagged and is going to cause extra TSA scrutiny. And that extra TSA scrutiny might lead to pat-downs. It might lead to inadvertent public outings in the middle of an airport lobby. And it's just something I think people need to be more emotionally prepared for as they travel. There's some specific tips that I'm going to share to help protect around some of that. There is a service called TSA Cares. You might not think TSA Cares, but it's a mandated assistance, and you can request it ahead of time before traveling. It's set up to enable disabled folks to travel more easily and get through the ruckus of the TSA screen. And it's absolutely appropriate to ask for a TSA Cares assistance to help with mismatched documents and IDs so that there's not added invasion as you make your way through the screening process. I've heard very positive reports that people who have requested that support get it and it goes well. There's also a pre-check enrollment possibility, and people who have self-declared their gender in the pre-check enrollment, TSA accepts that, and it helps things go much smoother when you travel. if you're not going to travel internationally, I heavily recommend that you don't use your passport, but instead use your California state-issued Real ID or license. So to do that, you have to get a Real ID, a license, or help your kid get one, and that will help avoid any mismatch issues. And it's recommended that you just pack, just the essentials. Uh, During the process, you remain calm. Anybody who's had to deal with TSA or security guards in general knows that calm, quiet, non-angry responses get you through much easier and quicker. And if there is a pat down that's going to happen, the person receiving the pat down has an absolute right to ask for the same gender agent as they in in, in sync with their gender identity. All right, I've been throwing a whole lot of law at you, and I want to just sort of emphasize here that things are in flux. So I want to highlight some current lawsuits that are pending regarding some of the things I've talked about. I've referenced them earlier, but these are sort of the biggies that are about to happen or in the process of happening. So we've talked about AB 1266, which gives this great access to participate in sports and safe and accessible locker rooms. And there is a um, claim being brought by both the Department of Justice and this lovely named organization that calls itself the Save Girls Sports, because we all know how girls' sports are terribly in danger by giving access to all girls. Um, so that bullet there, mismatch in gender marker may cause scrutiny, was not supposed to be in this section. So ignore that. That has nothing to do with the Title IX sports lawsuit. Um, but there is this challenge that's moving along with uh, at the bottom you have reference to the state pre-enforcement action that our Attorney General has brought a lawsuit that is acknowledging sort of the existence of the DOJ and Save Girls Sports claim, and is also seeking to prevent the Department of Justice from conditioning school funding on our schools not complying with our state laws that give full access and participation and use of bathrooms. I talked about the ACLU case, the passport case. The name of that case is Orr versus Trump. And just this month, a preliminary injunction issued that is preventing the marker ban nationwide. Because the ACLU brought it as a class action case, so it works its way around the U.S. Supreme Court not letting nationwide injunctions happen. And we have the parental notification suit. So AB 1955 is trying to protect kids' privacies, prohibit outing of kids and parental notification, and that's being challenged by lawsuits brought in Huntington Beach and Chino Valley, and our Attorney General is defending those suits. So we're moving to sort of my wrap-up slides, and I wanted to just kind of summarize what I've talked about in terms of what are the risks, and then I'll also summarize, I think, what some of the joys that we could be glad we've got. So just things that families should know about potential risks. Even though we have very, very strong laws, and I've highlighted those laws, there is a risk of care interruption. And that is because we're seeing care being disrupted because of federal pressure. And that even in California, with all the protection we have, we are seeing this both in the CHLA situation and at Stanford. I think people have to be cautious when they're traveling, and just that there are travel/documentation issues to be conscious of, and to know that if there's a mismatch in ID, that it could cause profiling and therefore different treatment at the airport, or it could cause delays. I wanted to just highlight that we have gone out of our way in California to pass school participation protections. But because of the lawsuits that I've mentioned, the access to sports activities and to facilities is under threat of reversal. So we just have to keep our eye on that. And particularly because those two cases are moving forward next term at the U.S. Supreme Court level. Clinic closures in general, whether it's because of federal pressure, because there's all kinds of funding concerns right now that are causing healthcare clinics to close, regardless of the pressure around providing gender-affirming care. Just it reduces provider availability. So with every closure, with less provider availability, it causes some people not to have access to the care they need. And with too much of that, it forces out-of-state travel. And we're trying to be a place that is encouraging in-state travel, that we want out-of-state people to be able to come here to access care. And I just want to also just acknowledge legal action fatigue. I've spent an hour now just talking about lawsuits, and some of us, like, we get up in the morning and just like, what am I going to read today? What, another day where I have to say, what the fuck? So I think legal action fatigue is real. Those of us who care about this issue and who care about our kids know that we have to stay informed. And we have to stay connected to the different advocacy networks. And you all came to this workshop. Thank you very much. But you also have to take care of your health, and don't like glue yourself to swiping your screen for each piece of bad news, and don't have to stay on top of reading every single case as it comes down. So think about how you need to balance those things. But on the happy side, this is sort of just going over the rights and legal protections that we do have, that I have talked about, and just to put them here in one place for you. Here in California, we have absolute protected care access. Gender affirming care is state protected in California statewide. And not only is there a right to access that care, but withholding it is discrimination. It is a violation of many state statutes, and we have an attorney general who is willing to prosecute those cases. Take advantage of the fact that in California we have safe ID options. We have non-binary X markers that could be put on your birth certificates. It could be put on your driver's license or your state ID. You could also, if the identity is not non-binary, it is easy to put a gender identity that aligns with your identity and not what was assigned at birth. And that can be done both on original birth certificates and licenses. And there are very accessible means of doing that. Easy to fill out forms. We have the school privacy safeguards. They are, as I said, everything has a pro and a con. Yes, they're under threat from lawsuit, but they exist right now. That students are safe to not be outed unless they have chosen to be out. And there's a mandate of affirming facilities in every school starting January of 2026. People should be able to pee in peace. And there's great legal resources available. I've mentioned more than once that our attorney general is willing to prosecute these cases, and has been, and is a good litigator. The ACLU is doing great work. NCLR is doing great work. Lambda Legal, all at the national level. GLAD didn't make them onto my list, but also exists. So if you or your family are personally having problems with any of the things that we've been talking about, these agencies are available to help provide legal assistance. And if you're not having problems and you have considerations around your charitable donations, please keep them in mind. So today in California, these are our legal realities. if we are concerned about state bans on minor care because our U.S. Supreme Court in Scrimeti just said those are possible, we don't have any in California. The legal factor of SB 107 protections. Here in California, we have created a shelter from any out-of-state enforcement of our access to affirming healthcare. Regarding federal funding threats, I want to acknowledge those do exist. They clearly exist. They may disrupt services. They have affected Stanford and CHLA. Healthcare provider privacy shields are strong via state law. And in terms of parental rights, in California, parents retain the authority for their minors' care. The state cannot tell them what's the appropriate care for their child. That's between the parents and their child and their healthcare providers to decide what is and is not the right care that their child should be receiving. So what should families be doing? What can families be doing? Stay in California. It's safe here. Use in-state providers. The care in California is legal and it's shielded. Monitor clinic closures. I'm assuming that folks all live around the Bay Area who are on this call. We have the Stanford closure, and I don't know if anybody here was using that, but otherwise there's a lot of access to care up here. But just pay attention and monitor what's closing around the states and be engaged and involved in what you need to do to make sure your family's getting the care it needs. Engage with your community, engage with legal support. If you have cross-state issues in your family, if you have split custody arrangements and they cross state lines, be aware that SB 107 protects against any custody or legal actions for obtaining the proper care for your kid within California. And I'm just encouraging all of us to just model an advocacy approach. Talk to your legislatures when things are coming up. Support legal challenges. Tell your story. So if you're somebody who likes to talk to the media and is comfortable doing that, please do. Please talk to lawyers so they could quote you in the briefs that they're needing to write for these cases that I've been talking about. I've been throwing out a lot of names in alphabet soup, so just to make sure you have some information on what some of the resources for advocacy are. The California Department of Justice, so not the federal DOJ, but our state DOJ, through our Attorney General, has a legal guidance hotline. Feel free to access that hotline anytime you want. I think it's 24 hours. And they could give you the current legal stance on youth care and school protections. Again, I want to praise our amazing legal service organizations that are doing the civil rights work to make all the positives that I've shared happen. So the ACLU California, NCLR, Lambda Legal, the Transgender Law Center, they're working hard to challenge some of the federal policies. They've been working on the passport cases and the sports litigation cases. I want to talk about local LGBTQ centers. Even though we have those centers that have closed, San Francisco Community Health is thriving. In Southern California, APLA remain open and providing great gender-affirming care. And at the legislative level here in California, we have a very strong LGBTQ caucus. They were very involved in getting, for instance, SB 107 passed. They're seeking to even more solidify our shield laws that we have in place. Access your local senator, Senator Weiner. Scott Weiner is very involved in the LGBTQ caucus. So to some concluding thoughts, and Avi, I started with kind of some dismal stuff about what's going on federally, but I just want to say that California remains one of the strongest states for trans youth rights. We've passed some really powerful laws, and we're enforcing those laws. And I don't want to deny that there are significant legal threats that persist, both from the federal actions that I've mentioned and from lawsuits that both exist to pursue the federal actions and to try to diminish the strong state laws that we've put in place. That all of our families need to stay vigilant, and part of doing that is tracking our care providers, documentation that I said is becoming more important, school policies, and, without obsessing, pending legislation. That kind of persistent civic engagement, advocacy, community resilience, all that was essential for creating California as being one of the strongest states for trans youth rights, is because we've been doing this all along, and we need to sustain it and keep them in place because we have a continuously evolving legal landscape. If I had prepared these slides a month ago, I would have said really different things. So it's constantly evolving, and we just have to support each other as we try to keep up with it. And now I am ready to answer your questions. So I'm going to stop the share so that we can see each other, or you can see me already, but I can't see you, and to see what's in the chat and answer questions.
Well, Ora, this really, I think everyone's saying the same thing. This really has been truly informative. So thank you so much for your time.
A pleasure. Thanks for inviting me.